So, interestingly enough, yeah, I've been around a little while. Rob reminded me that we met when I was running for the Young Lawyers Board at the Philadelphia Bar Association nearly 25 years ago. So I, too, am a licensed attorney. I litigated here in Philadelphia and really found the same love as most of you, which is the love of proactive and strategic communications. And so with that, we have this compliance industry that we have to think about ethics and rules. And I'm going to talk about them in a number of ways, like what's coming down the pike and what do we really need to worry about. But it's something that we all have to be cognizant of. I have to say that I have worked with Stacy and Jason for years, know them, respect them, and have learned a lot from both of them. And what I love about our industry is that we are such a collaborative, supportive industry. So I thank you both. And I want to thank Panet Schwartzy as well, because they're hosting us, and we've been working with the firm for quite a number of years and are honored to be here. So since ethics can be quite boring, I don't like to be a boring speaker, so I'm going to entertain you a little bit too, and it's not with my voice.
Thanks, Dan. Thanks, Dan.
Thanks, Dan.
Thanks, Dan.
Thanks, Dan.
Thanks, Dan.
Thanks, Dan.
Thanks, Dan.
Consequences. They sure suck, don't they? America was built on freedom, not on a bunch of people with more money than you telling you what you can and can't do with all their stupid laws. Laws are arbitrary. Hi, my name is Daniel Music, and I'm a criminal defense attorney based in Pittsburgh, Pennsylvania, and I stand ready, willing, able, and committed to defend you on all manner of criminal charges, including murder, arson, burglary, bank robbery, simple and aggravated assault, and possibly even funny throwback crimes such as moonshining or pickpocketing. When you're charged with a serious criminal offense, you're facing the fight of your life. You need a lawyer who understands you and understands where you're coming from. Trust me, I may have a law degree, but I think like a criminal. Street knowledge. A lot of criminal defense attorneys around town are going to take your money and then blow you off. That's not me. I pick up the phone, I answer calls, I return letters, and I make jail visits, because I'll probably be there visiting my friends anyways. I'm the Pittsburgh criminal defense attorney Pittsburgh criminals hire when they commit crimes. I'm also licensed to practice in every single county in the Commonwealth, so don't feel left out, people in Beaver, Mercer, Crawford, Venango, or even Lehigh County. I'll go anywhere. Any criminal defense attorney who promises you a result is most likely a liar or a scumbag. But what I can promise you is my committed fighting effort to ensure that you are adequately defended on any charge that you're facing. Pay me now, thank me later, and remember, you keep your trap shut, and I'll keep your trap open. Did I mention I'm Jewish?
Daniel Music is licensed to practice law in the Commonwealth of Pennsylvania only. All participants in the commercial are actors, and their participation should not be construed as an endorsement. No results are or can be promised by Daniel Music. Any actors who may have committed the crimes they portrayed did so without the knowledge or consent of Daniel Music. This advertisement should be considered a satire and entertainment. No actual crimes were committed in the making of this ad. All weapons and drugs were props and or facsimiles.
I can't do much more with that. Does anybody want to know why we have the ethics rules? I told you I was going to entertain you a little bit. Has anyone seen this before? This is a real commercial, okay? Anyone want to share with me what some of the ethics violations are?
Guaranteed outcome.
Guaranteed outcome, absolutely. I'll throw some out there quickly. It creates unjustified expectation. He says he's licensed in every county. Counties don't license. He ensures, that you're adequately defended, makes a promise. And he says, you keep your trap shut, I'll keep your trap open. Who knows what a trap is? Thank God nobody answered. It's a drug house.
Oh my God.
Yeah, so he's promising illegal activity. And this is a real commercial. I do think, however, he spoke to someone about SEO language because he hit the nail on the head, right, Jason? Yeah. You'd say so. So why the changes? We all know the model rules in all states and the ABA model rules are rather antiquated. They wanted to encourage national uniformity. One of the things that the ABA found is that when they looked at all of the states' rules, we've moved so much further ahead of them that they had to play catch up. So they tried to be as modern as humanly possible with a committee made up of lawyers over the course of 2 years. So, and you'll hear me say this throughout the presentation, it's what we have right now and what will be relevant down the road. It's not relevant yet, and I'll explain that. But what we need to know is that they're going to continue to change, and the states may adopt it with even less stringent provisions. They want to talk about technology, competition, cross-border practices, all the things we do every day. We know their issues. We're addressing them. Our lawyer counterparts are now coming to the table and addressing them too. So I just want to show you what this looks like.
Good afternoon, members of the House. My name is James Williams. I am the state delegate from Washington, and I rise in support of 101 for 3 reasons. First, just briefly, the purpose of this resolution is really to level the playing field for our lawyers all across the country, recognizing that they are battling with entities that are not lawyers for business, and they do have the right for commercial speech. Second, this is about truth in advertising. Lawyers have a right to be honest and truthful about their services, and the public has a right to know. This resolution moves in that direction. The third point is this. Other organizations, state bar associations, are already moving forward in this direction. Specifically, Washington and Oregon have been much more aggressive than this proposed resolution. So for these reasons, we support Resolution 101, and we ask you to join us.
Thank you. I see no further indication of people wanting to speak in favor of the resolution. Mr. Parra, I assume that wave means you're waving closing. We will now move to a vote on Resolution 101 as revised. All of those in favor of Resolution 101 as revised, please say aye. Aye. Those opposed, no. The ayes have it. Resolution 101 as revised has been adopted.
So you're going to get a follow-up email with a PDF with all of the information in this presentation and all of the links. So for example, if you actually wanted to watch the entire presentation that's about 17 minutes on why they were making these changes, that link will be in there. So you don't have to worry too much about taking notes. I'm sending you everything, including the ABA model rules and the Pennsylvania model rules. So it's all in that handout. You'll receive that after the presentation. So the rules that were changed, we in Pennsylvania in particular are used to talking about 7.1 through 7.5. 7.4 and 5 are no longer part of the ABA rules. They have been incorporated into comments. And this is what we are going to see likely moving forward as each state adopts the model rules. So I need to be very clear, these are not the standard for Pennsylvania, New Jersey, Delaware, New York, New Jersey, and any of the other states you're working in yet. We're still working under the current rules, because each state has to adopt the ABA model rules. And so they're going to look at them, and they might take 1 to 2 years to adopt them, at which point the ABA may be revising them again, because this is the process that we've been dealing with for 41 years. And what's interesting is the Bates case is 41 years old, and our industry is a heck of a lot older. Some of the things that they have changed I really do like, and we'll talk about those. The changes, they permit nominal thank you gifts, which is something we have all had to grapple with. Oh, can I send a thank you basket of fruit for that referral to a non-lawyer? They prohibit live solicitations. So technology is a big reason why the rules have changed when you think about texting, Facebook, FaceTime, and they're mostly, by the way, a lot of the changes are very much geared towards your business to consumer practices. However, something like being able to send a nominal gift is very much geared towards all of our businesses. Eliminate labeling requirements for targeted mailings. Hopefully we won't have to put attorney advertising at the bottom of everything we send, right? We laugh. If you're in Florida, it's got to be a certain font size and red, and prohibit misleading, coercive, and harassing mailings. These are probably not things that you deal with, but the general consumer does. We know that oftentimes there are attorneys who will go and buy lists of people who have been injured in an accident or arrested, and then we'll send them solicitations. We really want to get away from things like that. So for those of you who don't know Will Hornsby, he was at the ABA for 30 years for their professional responsibility attorney. I've presented with Will probably 10 times in the last 20 years. He's now consulting on ethics and professional responsibility. And I called him and interviewed him, and this is what he said. And I really wanted to make sure that I understood before I told anyone, why does this matter? And he said, well, it really doesn't yet, but it will, and we need to be talking about it. So I want to share that because he, to me, is the guru of legal ethics and professional responsibility. So we're going to start with Rule 7.1. And as I said, it's a little boring. So I'm going to have a couple other commercials for you just to break it up so that you laugh a little bit, because the rules can be a little tedious. The language in Rule 7.1 of the ABA model rules has not changed, the actual rule itself. And it's identical to the Pennsylvania model rule as well. However, the comments have changed. And so I'm going to show you some of the comments. I didn't put them all in the entire presentation, but they are in the handout, because you will need that possibly in Pennsylvania by next May. So you'll see that, for example, 7.1 includes Rule 7.5 in the comments. So this is your general checklist when we get to this next year of what's the same and what has been substantially edited or what is new. And so I try to do this throughout the presentation so that when you get the materials from me, you can just focus on what you need to focus on. So for example, you cannot create a likelihood that a reasonable person would believe they need to take further action when none is required. That was edited. New, you shall not provide information about fees without indicating the client's responsibilities of cost. And then, just to go through some, because I'm not going to read them all to you. You can obviously see them. Shall not be dishonest, fraudulent, deceitful, or include misrepresentation. They took a lot of time on this. So we've been monitoring this. At the LMA level, we have a standing committee that it was monitoring the rules and the recommendations and trying to figure out how we were going to respond before the vote, because we wanted to see them go through. We wanted to see the rules modernized a little bit, and there were so many revisions to go through. And you would think, we'd get through it probably in a day, vote and be done. But every single word was looked at. So in comment 6, that's where you're going to find the formal rule 7.5 about firm names, letterheads, professional designations. And yes, you can still have deceased members' names in your firm. This is a big issue, by the way, right now. So with it's succession planning. We have a huge opportunity in our industry right now. We're seeing so many of our, in particular, Philadelphia, New Jersey, and New York and Delaware traditional firms that have been around a long time. And there's a lot of succession planning going on. And if there's not, there should be. And what's the firm going to look like 5 years from now, 10 years from now? What's the name going to be? And these are the calls I have with CMOs and CBDOs almost weekly, if not daily. You know, well, this partner retired and this one died, and do we have to take their names out? And so these are things that, believe it or not, we do have to think about, and we're going to see it more and more in the coming decade as most of the founders of all of our big firms, many of whom are represented here today, are retiring and or moving on to other horizons. So this is something to be mindful of. You can now, when we had to have the address, the local address, you could have a website address now. So that's going to be a big thing because of all the virtual firms. Geographical names may need to include a statement that the firm is not a public legal aid organization. So we've actually seen some of these things where there have been some law firms that have put themselves out as associations, like the Association of, this doesn't, you know, Intellectual Property Counsel. And they make it seem like they're something other than a law firm for credibility. You can't do that. So these are some of the things that, and they actually did review ethics complaints and violations throughout the US to come up with a lot of these the recommended changes that have now been adopted. So claims in advertising cannot create unjustified expectations. We know this hasn't changed. I get to say hello. Law firm names can't be misleading. We know this, including incorrectly suggesting affiliation among lawyers. And again, I don't have these rules memorized, so forgive me if I'm reading, who simply share office space. So this is that idea of, we have a lot of co-ops, and they're looking at how does that affect the consumer perception if it's really just a solo and they're holding themselves out to be a part of a larger entity. So that's 7.1. Are you ready for another one? Some of you who always watches the Super Bowl and commercials? Okay. Who watched it last year? All right, there we go. So you may have seen this.
I'm Jamie Casino. You may have seen some of my personal injury commercials on TV. I wasn't always a personal injury lawyer. I once was a notorious criminal defense lawyer who was employed by some of the most cold-hearted villains. My art brought me great wealth until one day my little brother Michael and his friend were 2 of 4 people whose lives were taken.
Your brother was involved in a situation last night. He was shot. He didn't make it.
After the tragedy, our chief of police deceived you to make it look like the police department hadn't lost control.
No innocent people were targeted.
Daddy, what do you do when you go to work?
At some point, a man must ask why God created him. I'm attorney Jamie Casino, and I don't represent villains anymore. I speak for innocent victims who cannot speak for themselves.
Anybody see this before? Exactly. That's how it cost an incredible amount of money. He ran it, a 2-minute commercial during the Super Bowl in 2014. And interestingly enough, from a consumer marketing perspective, it's brilliant. It's a brilliant media buy. It got tons of media attention. It went viral in Savannah. And the return on investment was unbelievable. So would I produce a commercial like this? Not likely. Be a little bit uncomfortable, the lawyer and me. But it was really interesting. He did everything from using hashtags to getting out the story in the press, and nothing he said violates the rules of ethics. He's telling a personal story. He's saying why I went from this type of lawyer. He's rebranding in a really kind of interesting way. Now, would any of our law firms go for something like this? No. But it's fun to look at and fun to see, you know, again, why are the rules there and what works, what doesn't, what can we tolerate and what can't we? But I thought his media buy was brilliant. I mean, if you really want to think about it from the perspective of return on investment, if you're going to, and the video itself cost a ton of money, an absolute ton of money. I find it, you know, the first time I saw it, I laughed, but I was actually watching the Super Bowl and I went, are you kidding me? A lawyer ad during the Super Bowl? Wow. You know, I used to buy that kind of media and consumer advertising, and it's rather expensive. So on to Rule 7.2. So Rule 7.2, and what's really important here is that a lawyer may communicate about their services through any media. Any media. So this is where we used to talk about advertising, specifically advertising. And in the rules, there were a couple of different types of media that they would point to. But now the ABA realized that there's just, we can't even list them all, right? You can communicate in, and then of course there's always exceptions. So that's the main thing, they broaden it. This one is the one that allows for nominal gifts and updates the office address requirement to contact information. And that's really important. And it'll be interesting to see how some of our states that we deal with address that, and whether or not they're going to still say, well, you have to have an office location, not a shell in New Jersey. You know, because I'm sure many of our law firms, we deal with that, whether or not they have an actual office or rented space. Same thing with New York. And so these are some of the things that will affect us if it changes. Might make it a little bit easier for our firms to become more virtual, more diverse, more, you know, so there's a lot of benefits to some of these rules if you don't have to have a physical entity in the state where your attorneys are licensed to practice. So they're starting to change that a bit. 7.2 is virtually the same, where it adds the comment B5, or not, I'm sorry, this isn't a comment, this is within the rule, B5. You can give nominal gifts that are neither intended nor reasonably expected to be a form of compensation for recommending a lawyer's services. So this also, one of the big things that they were addressing and continue to address are referral services, where you can, Avo was one. Did anybody see the news about Avo, the new branding? It's now Martindale Avo, Martindale-Avo. That's because Martindale acquired them, and they announced the name change yesterday. So, but that was one that sparked some of these types of things. You know, can you pay to get these types of referrals? And this is nothing that we haven't been looking at for quite some time. And comment C is the former Rule 7.4 on communication of fields of practice and specialization. This, I think, affects almost all of us, and it's something that we want to continue to be mindful of. So, for example, if you are actually certified, if any of you have firms that have workers' compensation practices, for example, the Pennsylvania Supreme Court sanctioned certifications just a few years ago. So that became a new opportunity for firms in that space. It's very, we know that there's other types of certifications. You have to identify the certifying organization. Paragraph C permits a lawyer to communicate that they do or do not practice in a particular area of law. This has always been one of my issues when law firms have so many practice areas on their website or in their materials, but they actually refer out most of it and don't say that they refer it out, and that's still an issue. So they want you to say what you do or don't do. I've been giving this presentation for so many years on ethics, going back to when I was a young lawyer 25 years ago. And what's interesting is I love the fact that we can now say they are a specialist or specializes. These used to be these was in my list of taboo words. Still can't call a lawyer an expert, but you can say they concentrate, because what we're saying is this is predominantly what they do. And I think they finally looked at the English language and realized there's not a whole lot of other words, right? I mean, our attorney has handled 50,000 cases in this particular area over the course. They specialize. They focus their practice. So now they're saying it's okay to say that, even though we've been saying it all along. So one of the things we're going to talk about in a little bit is do these really matter, right? Because a lot of legal marketers throughout the US are saying, so what? We've been doing this anyway. For the IP practices and firms in the room, the rule hasn't changed with regard to your patent and trademarks and the types of work you do. Same with admiralty. Those are considered specialties, as you will. And the rule permits a lawyer to state that the lawyer is certified as a specialist in a field of law that allows for it again. So these are things to be mindful of. And then this was just the specific change on the contact information. Includes website address, telephone number, email, and I purposely highlighted the word or, because when you go to law school, for those of us who are crazy enough to do that in the room, we would have days and days of conversations about the words and versus or, right? So that's why I highlighted it, because it does matter. And this is directly pulled from the rules. And so these are the types of things that we grapple with. Yeah, I mean,
so what is the rule?
The rule is you can, if someone actually has a certain, they don't even give you 10 years experience or 50% of their practice. They don't share that with us. So we have to make an assumption, right? It is very subjective. And the thing is, the rules have always been subjective, so they tried to make them less subjective, but they're never going to get there. And the truth, how many of you have committees, marketing committees in your firms with more than 2 attorneys? That's it? Nobody has, how many of you have more than 2 people who have to make a decision on marketing, business development, public relations, mergers and acquisitions, anything like that? More than 2 people. I would hope, I mean, be most of you. The thing is, there were so many people collaborating on these that they were never going to get to full consensus on every piece, but you're right. You're reading it right. We can say specialist when it is certified or specialized by a particular entity. You need to mention the entity. So I would never say that I was a specialist in any practice of law, because I haven't practiced in 20 years. But other attorneys, for example, who have focused, let's say someone just does M&A work, and that's all they've been doing for 15 years. I don't have a problem saying they specialize in M&A. Fair enough? Does that answer your question? Still leaves it a little bit ambiguous. And I realize that. I think they intended it that way, yes. So here we go.
Hi, I'm Steve Miller. I've been a trial lawyer in Florida and Massachusetts since 1985. If you and your spouse hate each other like poison and want to get out of the hellhole you call a marriage, you've come to the right place. Look, you can waste your money screwing around with some paper pusher paralegal type, give thousands of dollars to some piece of crap 3-piece suit downtown, blow your brains out trying to figure out why you wasted $25 on the crappy forms you bought from the illiterate boob at the courthouse, or do what I say and do it now. We know what we're doing here. Look at this website, a work of art. Here's the story. Pay us a little and we get you a lot. Don't worry about the details. We'll take care of business and let you know when to crack open the champagne. Okay, time to move on. Go to the Get the Divorce page in the upper right corner, pay up, and you're on your way to getting rid of that vermin you call a spouse. We're here to help. Divorce EZ, a Florida law firm.
What is the primary ethical violation in this, other than it's just tasteless? No. No. Not even that. It's the name of the URL, Divorce EZ. The Florida bar found that it violated the rules and had him take it down. Now, it's still on social media. You can find it on YouTube, just like I did. But it was very interesting. So, and if those of you who have any offices in Florida know that the rules are completely, right? They're completely different. I'll usually say to any multi-jurisdictional law firm, if they ask us, I'm like, just defer to Florida or Indiana, and you should be okay, because they're very strict. And oftentimes New York and New Jersey, if they have offices there. But this was deemed unethical. I found it completely tasteless personally. He had done, if you Google him, he had done some very calm, hi, we're Florida divorce lawyers. And they were very professional, boring. He's not a good speaker. Didn't get any engagement on social. So they went for shock value, and they got a ton of engagement. They actually got a lot of business as a result of it. So what's one thing we know about most people going through a divorce? They're bitter and angry, because it's the worst thing that many people can go through. So they capitalized on emotion. It had to be taken down, but they're still fine. What I don't understand, so I don't understand how it can stay on YouTube and not be required to be taken down, but nobody follows through. So when we talk about the rules and these types of violations, nobody's following through. There's not a state or an ethics committee that actually does much about it unless it's super, super egregious. So he was told he couldn't run it on television anymore. Who watches television? Right? Everybody's watching stuff on computers and iPhones and iPads, every kind of device. So that's one of the things that I find interesting in the whole conversation, because you've all invested time in hearing from me today and saying, well, how does this matter? And we're held to this standard. We're held to all of these standards, and that's our jobs. And yet there really is no police department policing it. What I always tell law firms that request that we go a little bit too far is that they're not policing it until your competitor comes after you. And then I don't want to do your crisis response. So that's where it's one of those things that it's, you're darned if you do, you're darned if you don't. But we do have to be mindful. So with regard to solicitation of clients, solicitation or solicit, they actually define it, denotes a communication initiated by or on behalf of a lawyer or law firm. The or law firm was very important because most of your lawyers are not doing the solicitation. It's the marketing, or it's someone sending out the email, the e-blast, the commenting on the LinkedIn query, things like that, that are directed to a, quote, specific person the lawyer knows or reasonably should know needs legal services in particular matters, and that offer to provide or reasonably can be understood as offering to provide legal services for that matter. So this is the idea of, so what's important about this are the exceptions. And this is where what are going to matter to most of you. So the exceptions are if the person is a lawyer, has family, close personal or prior business professional relationship with the lawyer or law firm, or the person who routinely uses business purposes the type of legal services offered by the lawyer. What that means is general counsel. Anybody or a business owner who normally would be working with law firms anyway. So there's a lot, again, talk about ambiguity, right? There's a lot of ambiguity there because they don't define exactly who those people are. And one of the things we love as lawyers is ambiguity because we can argue just about anything away. We do know that consumer practices are marketed very differently, and the majority of these things affect consumer practices. However, I think the nominal gifts is important. The address requirements are very important. The mentioning attorney advertising on everything is very important. And this last one, persons who routinely do business with law firms, because that really takes the onus off of us quite a bit. as legal marketers. Yes. Yes. That is much of the key, is the live. And so the problem is, what do we define as live today? And so then we get into the whole conversation of, is a letter sent via Facebook while you're live and the other person is live, is that a live communication, even if the other person doesn't have to respond? So it's real, again, there's a lot of ambiguity in these rules. I'm sure everyone has gone through the whole GDPR review in their firms here and how that affects it. And it all plays into it. And what's going to be interesting is how each state interprets the model rules and what they accept and what they don't. Because as of right now, this doesn't really matter until it gets applied. So this is what we're doing in the big picture, what's going to be applied. But these are all great arguments, and one of the things I love about presenting to an audience such as yourselves is we've all been dealing with this for a long time, and there are a lot of questions. And these are some of the questions we were bringing up and why there were some naysayers before the resolution was voted upon, because they felt that there was still ambiguity. So I believe these rules are all going to go away at some point. That is my belief. When, how, if, I don't know. But the industry is changing rapidly. We're dealing with accounting firms that have legal services now. We're dealing with virtual law firms. We're dealing with clearinghouses. Our industry is changing at such a rapid pace that most of the marketers that I interviewed about these, the legal marketers, felt that they were already antiquated before they were even adopted. So that's something to really think about. However, we still have to do our jobs. We still have to do our jobs, because if we screw up and the firm gets in trouble, who's to blame, right? So it's not throwing caution to the wind, as you will, and just being mindful. A lawyer shall not solicit professional employment even when not otherwise prohibited by paragraph A if the target of the solicitation has made known to the lawyer a desire not to be solicited. So this is getting into your Can't Spam Act, things like GDPR, or the solicitation involves coercion, duress, and harassment. And so where they're arguing is that some of those letters that are sent out when somebody has been arrested, or that they can come across as coercive or harassing. So that's where this came from. Does not prohibit communications authorized by law or ordered by a court or other tribunal. So if you are required to send something out by a court of law, then that's not going to fall under the rules. Notwithstanding the prohibitions in this rule, a lawyer may participate with a prepaid or group legal service plan operated by an organization not owned or directed by the lawyer that uses live person-to-person contact. So now this is live, right? So we're back to enroll members or sell subscriptions for the plan from persons who are not known to need legal services, not known to need legal services. This is, again, things like LegalZoom, where you can subscribe to get a certain amount of services or a certain number of contracts. And this is also designed to look at some of the new types of law firms that we're seeing popping up throughout the United States. In fact, I met with a firm at Legal Week last year that is strictly a virtual bidding firm where they hire 1099 lawyers, and other lawyers from throughout the country can bid for their services to assist when they need additional support. I thought it was fascinating. It was much like some of these websites that you can go in and bid for a logo, or bid for. So it's a whole new service offering and they've been extremely successful, and it's venture capital backed. So interesting. So then we get into the whole ownership conversation, which we're not going to have today. That gets ugly. It deletes advertising material labeling requirement. There's a lot of duplicity in the rules, in the old rules as well. So they tried to clean that up a bit. Includes person who routinely uses business. No longer prohibits real-time electronic solicitation due to the so this is where we get, you can have real-time texts, tweets, written communications, it's how it's perceived. So it's always going to come down to how the recipient perceives whether or not they're being pressured. And specifies that communications authorized by law or court order, including notice of class members, do not violate the rule. That's really all about class actions and MDLs and things of that nature if you work in that area. Now again, I keep saying these things, but I want to keep repeating because I'm being filmed that they will only apply when states adopt that. And all of this is in your handouts too. I really don't want to keep, you can see it behind me, so I don't want to keep reading it. And I'm going to make sure that you get these electronically. So moving forward, the Pennsylvania Committee on Legal Ethics is currently reviewing the rules, and they are meeting with the House of Delegates in May 2019. So if you have questions, I've provided the ethics hotline. A lot of big firms here in Philadelphia have members who are reviewing the rules as well, as is the Philadelphia Bar Association. I called Charlie Klitsch and we spoke, and he said basically they are reviewing them and going to be making their own recommendations in partnership with Allegheny County, since we're the two largest bar associations in the state. And they're going to be making their recommendations in advance of May 2019 so that they can be considered as part of what we hope the House of Delegates will do. So do I have any idea of what they're thinking? No. And it's going to be all over the place, is my opinion. And I suspect that a lot of states are going to decide to go in their own direction. And even though the model rules were meant to bring everyone together, my gut, and this is just a prediction, is that every state's going to go in their own way. Some are going to be more conservative than others. That's my gut. I hope not, but that's my gut right now. And if you see these things in other states, I will tell you at LMA, we're really looking to find additional resources of people who are involved with the conversation in their own states, because so many of us work with practices all over the country or globally, so we're looking at that as well. So one of the things that I found this quote really interesting, and I pulled it out purposely, and I love this blog, myshingle.com, but why the revisions represent everything wrong with the ABA. And I wanted to share some of these things because we have to grapple with these every day, but there's a lot of skepticism and a lot of frustration. And we may, they talk about it being enforced silly minutia. They don't enforce it anyway until you're the one. And we've seen a couple of lawsuits in Philadelphia where competitors have filed lawsuits against competitors. I'm not going to mention any of them, especially not while I'm being videotaped. But you don't want that to be your firm. That's really what it comes down to. So I wanted to leave a little bit of time for discussion. I interviewed about 20 legal marketers from various size firms, from AmLaw 100 on down. And these were the things that we talked about. Don't the changes merely approve conduct that lawyers have been engaging for years? Yes. Don't the new rules simply state the obvious? Yes. I have a feeling many of you are thinking these things, so I really wanted to validate that thought because we're all thinking it, but at the end of the day, this is where we're going to be, and perhaps in Pennsylvania come May 2019. Will they matter in a few years when lawyers are no longer the preferred providers of legal services? Right? And that's a big one, and I think a lot of us are in denial.
Who do they assume will be, robots or the Big Four?
We're very worried about the Big Four. We know that. But there's all sorts of alternative legal service providers coming out. So the industry is changing. We all have our work cut out for us. I love what I do, and I'm pretty sure you're here because you enjoy what you do as well. That means we really want to help our firms to continue to grow and to continue to evolve, which, and I will say this on tape, is very difficult with law firms that are stuck in their ways. So we need to help through the evolution so that we remain relevant and viable in the future. Yes, Cole?
What is the rule on testimonials?
I don't know what the rule on testimonials is anymore. I don't know that it was really clearly addressed. We've always been very careful with testimonials, but most firms use them as long as they don't violate Rule 7.1 and 7.2, like create unjustified expectations. So it really, they have to be truthful. So don't go and write your own testimonial from the client that never existed, which I've seen, by the way, and put it on your website. Or if you don't have permission from the client to post something, make sure that something they provided is so generic that they could never be identified. We see that a lot in the personal injury space where they will say, we got a $20 million verdict in a construction accident case. That could be anybody. That could be anything. Hopefully, when they post that, it's actually true. You know, so they really didn't get deeply into it, but I would say always look at the rules. Is it truthful? Does it create unjustified expectation? Now there are states where you still can't use them. Indiana, for one. In fact, they can't, lawyers, as far as I know, as of the last time I checked, lawyers cannot accept LinkedIn recommendations in the state because it violates that rule. So that's, if any of you know Nancy Merland, who is out there, she's one of the people that I'll usually call if we're going to be doing anything out in the Midwest and say, what's the rule? Because they can change. But that was a whole big thing. Do you all remember when LinkedIn started and we had to worry about all the recommendations, right? And some states said it was okay and others didn't. And then we had the big super lawyers argument in New Jersey for a long time. And so, you know, it's evolving. We're getting there. I hope for all of our sakes that there's no more ranking services ever again. Okay, for all of our sakes. Because I keep getting letters from clients saying, is this legit? I'm like, oh, no. You know, so it's just, and it really, it wastes so much of our time and productivity. So I'm going to give you one more, and then I'll take a few more questions if we have time.
Someone just called me! Ron Wilson, the Texas Law Hawk! Ron Wilson, the Texas Law Hawk!
I'm a criminal defense attorney in Fort Worth, Texas. I'm loud and proud of my Texas roots.
BBC trending! Do process! Do wheelies!
Texans are known for being crazy, and my ads are no exception, but I think we take it to a new level.
It's hot out here!
I always try to teach a legal lesson with each one of my commercials.
These things are 100% accurate. Blow it! Surprise! Fail! Someone just called me!
At first, our goal was to make it kind of look like it was half-assed, but still make pretty good-looking shots.
Anchor of justice!
With that anchor, I mean, that thing was PVC pipe wrapped up with duct tape, filled with concrete.
Talons of justice! Brian Wilson, the Texas Law Hawk.
What came is an unceasing onslaught of hatred and just vile commentary. This guy's such a joke. What a douche. Douche was a pretty common one. He ruined his whole legal reputation in a minute, 6 seconds.
This may be the best commercial ever. Take a look.
Brian Wilson, Texas Law Hawk. Brian Wilson, the Texas Law Hawk. Talons of justice.
I got a phone call from Taco Bell and wanted to do a Super Bowl commercial with me. I love Taco Bell, and I thought it was one of my friends that was just, this will be funny, let's mess with him a little bit. And thank God my assistant called them back and verified that it was accurate.
This is going to be bigger than that Texas lawyer guy.
Brian Wilson, the Texas Law Hawk.
That was a really cool one. Filming that commercial was probably the best day of my entire life.
I'm Lowell the Hammer Stanley. When you call me, you get 35 years experience battling the stingiest insurance companies for hundreds of millions of dollars.
Glenn Lerner, what are you doing?
I'm working.
Look, it's Glenn Lerner. Hi, Glenn.
Working.
They've got a lot of clients calling me to the point where I've got to hire somebody to be able to help out. It was a one-man show for quite some time.
Ryan Wilson.
A lot of people saying that I'm not taking my profession seriously, and I disagree with them. If anything, I take my profession more seriously than a lot of other attorneys I've met.
So I watched a bunch of his commercials, and I decided to give you this, which was a compilation. It's cracks me up. And ethics can be such a heavy conversation and so technical and a lot of copy. So I wanted to give you something fun to look at too, to break up the day.